Welcome to Solving Citizen Legal Encounters. Wait a minute, somebody just bust through the door. Colin is here with the gang. Good to see everybody. Good to see you. Good to see you. Always had to mute. Yeah, good to see everybody. Yeah, appreciate that. Oh, we got everybody in the house. A Colin Ray. He that came in, bust the door down, and now everybody's inside. I'm so glad to see everybody. Thank you for coming through. We're gonna have some fun tonight. Okay. I really appreciate everything. So before we get started, I just want to let you know. So you saw the title, you may have seen the thumbnail, but you know how it is when you have a show, right? You always wait for the main guest to come out last. So I got a couple of clips first, okay? Then we're gonna get to that main event. All right. I know y'all good with it. Plus, I like hanging out with you for a while. So we're about to do this, okay? All right. Let's go.
File 21-20605-FC, People versus John Mitchell Stover. We are here today for arraignment on several bench warrants, and we are proceeding today by video conference. Sir, you are John Mitchell Stover, correct?
Yes, Your Honor, I am.
Hey, one thing I meant to mention before I start this up. For those of you who have not seen this yet, there is a trigger warning in here when he reads off the charges. So I already pre-recorded where the notification is you're gonna hear it. I'm gonna say it, but I'm not saying it here. If you don't want to hear the charges, you can mute until it's over, okay? And it'll be a short period of time for that. I forgot to mention that in the beginning. So let me continue.
Have you received copies of the request and warrant for probation violation in your file?
I do not have the copy of the paperwork. The only thing that I had been given was hold orders.
Okay. How long, Mr. Stover, are you going to be at the Macomb County Jail? Do you know?
Your Honor, with all due respect and no disrespect, I do believe this matter is going to be here. I'm going to be here at least for over a year.
Okay, I'm just trying to determine whether we can send copies of your warrants to you at the Macomb County Jail. So if you're going to be there for a while, we can mail them to you there.
Okay.
In the meantime, I will tell you that there are four warrants for alleged probation violations in your file here. The first is filed on February 28th, 2023. That warrant alleges that you violated the terms of your probation by assaulting your girlfriend, Crystal Fenderson, by pushing her with your chest, getting on top of her and choking her while biting her left cheek, then grabbing
Warning,
her cell phone,
the reading of the
throwing it,
charges
and
are about
breaking
to
it so
begin.
she could.
There it is right there. There's your warning. It's going to be short. If you want, right after he reads them, if somebody wants to just mute it, I could just stop it, wave my hand, and we're safe again, okay? I just like to respect everybody because some things bother people. All right? Let's go.
Not call 911, then fleeing the scene, and your whereabouts were unknown. The second warrant is dated April 3rd, 2023, and that alleges that you violated the conditions of your probation by sexually assaulting your girlfriend, Crystal Fenderson, forcing anal sex on her while having your arm around her neck in a choking manner. The third warrant is dated July 28th, 2023, and it alleges that you violated the terms of your probation by assaulting your girlfriend, Crystal Fenderson, striking her with a closed fist to her left eye. The fourth warrant is dated July 28th, 2023, and alleges that you violated the terms of your probation by physically and sexually assaulting Crystal Fenderson, pulling her hair, biting her hand to keep her from defending herself, then using an extension cord attempting to choke her. He then got her ice to reduce the swelling in her head, and she suffered, and she refused, and he tried to force it on her. It also alleges that you sexually assaulted her on that date as well. You were, in this case, convicted of assault with intent to do great bodily harm less than murder. The maximum possible penalty for that offense is up to 10 years in prison. You do have the right to be represented by an attorney here today and at any other proceedings we have regarding this matter. If you're not able to afford an attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yes, Your Honor, I do.
Do you want to be represented by an attorney?
Yes, I do.
Okay. If somebody did mute, it's over. All right. Then we want to continue. And I meant to also say, this guy does a little bit of sovereign citizen talk, not much, and you'll hear it like towards the end. But I want to follow this guy because the next hearing, he may end up going full sovereign. I don't know. But you know how it is. The sovereign citizens always use the attorneys at first. And as soon as they get a little leeway, they fire them every time.
Do you have the ability to pay for your own attorney?
I do not at this time.
Okay. In just a moment, I'm going to deal with one other case first, and then I'll put you in a breakout session with someone from the public defender's office.
And Your Honor, if I could have the paperwork, please.
Yeah, in the meantime, we will send that to you.
If I may, Your Honor, is Miss Underwood going to be my attorney in this matter?
Yes, she is the person from the public defender's office that handles probation violations.
With all due respect, I'm going to recuse her now.
You don't have an option to recuse her. I can appoint the public defender's office if you've asked for your attorney, but you don't get to choose who your public defender is.
Well, there's just conflict of interest, Your Honor. I don't need biasness.
I'm not aware of any conflict. If there is a conflict of interest, then the public defender's office would appoint a special public defender for you, which I believe has happened with respect to the underlying case back when we originally went through this. So I don't know, Ms. Underwood, you might want to check into that if we're going to need to appoint a special public defender for him. I think that was previously a conflict of some kind.
Yes, it was, Your Honor. It was James Daly at that time.
What is the name of this individual, Your Honor?
It is John Mitchell Stover, S-T-O-V-E-R.
Thank you.
My apologies for that pause. I missed that because I don't like long pauses. He should be getting ready to talk.
And Your Honor, if I may address bond at this time.
All right, let me work out the attorney issue because you requested to be represented by an attorney.
Your Honor, we had this case back in 2021. It's my understanding that Mr. Malero had the case and it was conflicted out. And Daly's, our last note is that on July 22nd, 2021, Mr. Daly took the case.
Okay.
If I may, Your Honor, back at that time, I did not have an attorney. It was pro se. I did not have one Sam Malaro, and the situation was, it was unconstitutional from the beginning because
Mr. Stover, Mr. Stover, please stop, because we're getting into things that have no relevance to the current issues. You requested an attorney. Mr. Stover, don't interrupt me.
All right, the Clouder just liked and subbed. Okay, the Clouder, thank you for subscribing to the channel. And I saw one other thing up here I want to miss with somebody think I ignored them. Somebody sent, oh. I owe you a song. All right, I'll see what I can do.
You have requested an attorney. We're going to need to appoint someone, a special public defender, because there's a conflict in the public defender's office. We're not going to be able to do that today. So what I'm going to do is adjourn this until next week. I'm going to enter a not guilty plea for you on all of the allegations, and I'll adjourn this to next week. In the meantime, the public defender's office will go through the process of appointing a special public defender so that you can be represented at that time.
Yes, I understand that, Your Honor. I just want the record to reflect very clearly. I was pro se, and you guys gave me an attorney unlawfully.
Okay, well, if that's not sovereign citizen talk, I don't know what it is.
All right,
You guys,
that'll be
because
all. Mr. Stover, I'm not going to argue. I'm not going to argue with you today. The hearing is adjourned until next week, April 9th at 8:15.
I've asked you, Your Honor, to address bond.
What would you like to say about bond?
I'm asking for a nominal bond.
You have bonds on all of the cases, so you would be getting credit.
I don't, that's what I'm saying. I don't know of any of the bond amounts or anything. That's why it said it was for the amount of the actual case file, which was $13.98 or $68 or something of that nature, I believe.
Okay, so on the July 28, 2023 warrant, you have no bond. On the on both of the July 28, 2023 warrants, you have no bond.
I'm in the top, but I'm not in all caps. I don't have a name tag on this one.
On the April 3rd, 2023 warrant, you have no bond. On the February 28, 2023 warrant, you have a bond of $1,398 cash.
So just to reflect this clearly, you're saying that I'm getting credit for being here thus far. I've been locked up since February 1st, sir.
Correct. You'll be getting credit because you haven't posted bond on any of those warrants in this case.
Thank you.
All right. You can let them know that you're done with court for today.
Thank you very much. God bless you.
Okay, now we're going to go to the next hearing. I don't know if you've seen this. I actually had this for a while. I forgot that I even had it. Okay, but this is sovereign citizen Judge Shackelford Court who doesn't want to pay his bills. Huh? And you know we run into a whole lot of them like that. And I want to give a shout out. Sovereign Citizen Chronicles is in the chat. He said hello. He has a Sovereign Citizen channel if you would like to check it out. Okay, so we're going to go into this case, you know, the financial thing. whatever. But let's go.
All right, this is 2301408 JP Morgan Chase Bank versus Arnold Chavez appearances.
Yes, Your Honor. Christopher Royce, P49102 on behalf of plaintiff.
All right, Mr. Chavez, can you turn on your camera and tell me your name?
Chavez Arnold.
There you go. All right, so last time we were here, the parties appeared and I gave 10 days to submit answers to interrogatories. Were the answers to interrogatories filled out and returned?
Well, Your Honor, they were prepared. When I prepared for the hearing, apparently they were not sent. I did email them to Mr. Chavez this morning. However, the document production requests were, all documents were produced within days of the hearing, Your Honor.
All right, so Mr. Chavez, do you have all of that now?
No, like he said, I didn't. After 10 days, he just sent. I mean, I could check my email, but I haven't received anything from him.
Did you receive all the documents you requested?
No.
Typical sovereign citizen. I don't understand the charges, or I turned in the paperwork to the court, and I guess you guys don't have it. Same thing.
Mr. Royce, when were they sent?
They were sent on August 30th. Make sure that I'm.
No, we had a hearing on, maybe I have that on 10/24. We were waiting for answers to interrogatories.
Yeah, the interrogatories mostly related to whether there's compliance with the UCC and transfer of a note, and whether there was an assignment of debt, which of course there was not here.
Were all the documents submitted?
All documents, except for he had requested internal accounting records of Chase Bank, just generally, not specific. But the Chase Bank record relative to his account statements were provided.
Okay. So, Mr. Chavez, what is the defense on this case?
Well, before we get to that, let's see. Cherazad just became a member. Thank you for joining. I appreciate that. And go to the community post because there's something over there for you to look at, okay? All right? I really appreciate you joining. Let's go.
What is your defense?
Well, I needed to see one of the documents. Well, my defense is that.
My bad, y'all. I got to stop because these chats are rolling. Kimby, 63. Thank you for the super. I appreciate that. Hold on. I got another one coming. Thank you. 20 gifted memberships. I hope somebody, Artie Foz has one. Joseph has one. Sly has one. Cynthia has one. Turpin, Patrick, Glitter, Thorina, Crazy Cat. I'm just going through it. Let's see. Empire Lady 13, Mom Hawk, Double M, Blunt Trauma. I better not see you in person. Vicky Fred, Connie Bell, and Nerdo. Where you been, Nerdo? Good to see you. Oh, wait a minute. Vince, BC guy, Lisa, Marilyn. I think that's it. I appreciate you doing that. Now we're going to have fun, y'all. I appreciate that, okay? Let's keep it rolling.
You know, I've been researching the law and, you know, the powers of the banks. And it's more of a accuracy of the actual accounting that I'm trying to make sure, and, you know, make sure that everything is accurate. So it's not my intent to not pay anything, but I need to know, you know, based off the accounting, that I am paying what I'm supposed to be paying. And based off of what they're saying,
your last payment, I mean, back on 5/15/23, you owe $3,398.36. And they're coming for $3,398.36. I mean, that was the balance on the card at that time.
Another interruption. Sorry, I got to do it. Well, Colin, I see you're making it rain. Yeah. And legal fiction. Thank you for becoming a member. I'm gonna have a bunch of people to have fun with in the membership. That's cool. Thank you. Wait a minute. Legal Fiction, thank you for the 10 gifted memberships. I'm gonna go through them, y'all. I think it's only fair. Kimby Rash. Well, Kimby, then Rash. Stuart B. Chaos, Confusion, and Coffee. Okay. Roughneck Reacts. All right. Robert Thomas, Kelly Newell, Christy. Don't Say That. I like that name. That's pretty cool. Paula Graham, and that's it. Okay. Thank you. Thank you so much.
Like, that's why I asked questions, Your Honor. You know, you say you gave them 10 days to send it to me. They didn't send it to me. I just got an
But
email
Mr.
this morning.
Chavez, you're not disputing that you had the card, right?
But that's not the issue at hand, is what I'm saying.
No.
Hold on one more time. Ryan, please do not feel like that. You don't have to have money for a shout out. I'm shouting you out right now. Okay. Thank you for being here along with everybody else.
What is the issue at hand? The issue at hand is, did you have a credit card? Did you use money on that card? And did you not pay the card off? That's the only question.
Right.
Those are the questions.
Okay, my defense is I am the lender and they borrowed from me.
What did they borrow from you?
My personal security, which I'm entitled to rights to.
No, I'm not buying that. No. Listen to me. Listen.
It's not about, I have it. I'm going by the law, Your Honor. I'm not just making up
No, you're not
anything.
going by the law. You're making up the law as you go along. You took a credit card on. You agreed with that. And then you had a credit card. You used the credit card. You have a balance on the card and you didn't pay on the card. They don't owe you anything.
So when I asked for the application, the evidence that opened up the account, because they go by GAAP accounting principles. If my application opened up the account, that means there will be a credit on my account because that's a cash equivalent. That's what the law says.
All right. Mr. Royce, I don't have a motion for summary disposition in the file.
Yeah, we talked about that last time and I was going to file one, but this hearing was a little bit too early. The motion would have had been filed the next day. So I did not get that out.
Thanks, Colin. I like your comment.
All right, motion for summary disposition. We will have a hearing for a summary disposition on 1, 2, 3, 4, December 19th. Can I see that? 1 second. One second here. I have them.
No, wait a minute. December 19th.
Okay. It's gonna have to be January 9th.
Okay.
My clerk's indicating.
I will get that out right away. I had it prepared, but then I noticed that I didn't have enough time to actually serve it.
Yeah, motion for summary disposition, hearing date will be January 9th to 25th. And the motions to be filed forthwith, and a copy obviously is to be provided to Mr. Chavez. And we'll see you back on January 9th, 2025 at 9:30 a.m. for the hearing.
Thank you, Your Honor.
All right, we're all set.
All right, he has one more hearing coming. Somebody messing with Colin. Colin needs to prove his jurisdiction. All right, so he has one more hearing coming up, and then after that, this is the moment that we've been waiting for. All right, let's finish him off because same guy, just different credit card company, still wants to talk the same old sovereign citizen mess.
All right, and I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992 of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed. And then an objection was filed timely on this case.
Hold on. Colin said, because Colin probably remember more than me. He said both of these were on the same court date. That is ridiculous.
So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and they was working in my area. And I have proof of. I talked to them in the chat. They confirmed it, and I have they gave me a bill credit for the inconvenience, so that's why I wasn't able to attend because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. I'm setting a date. So what do we need discovery on this? Mr. Goethals, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right. And this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated under MCR 2.116, parent I. This court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense to this claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29 will be entered by this court, and documents can be submitted for that purpose.
I wonder if he spent that money on one of them scripts. I'm just saying.
And officer, I have a few more documents for that, and we're all set. All right, we're all set.
I
Thank you,
don't have
Mr.
no
Arnold.
words.
Mr. Arnold, I have ruled against you.
I
I
have
am allowed to
evidence.
do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Goodbye.
Thank you, Your Honor.
She shut him down at the end. She wasn't trying to hear any of that mess. And once Judge Shackelford get going, that's it. All right, so now we're here for the main event. This is gonna be a good one because I already covered him before, I think on the last live where I did all of his hearings and how he went from sovereign in Judge Washington Court to praying in Magistrate, was it Garwood Court? Then praying in Magistrate Braley's court, or talking all this, like he's suddenly went spiritual or whatever, to Judge Simpson. All right, y'all ready? Let's go. Oh, let me just give you a heads up now. You know how Judge Simpson's court is with audio sometimes. Well, a lot of times. So I have raised the audio on the points from behind the podium if you can't hear them. I think before he split the hearing. So I think this one's good, but the second half might be a little rough, but you can hear it. Yeah, Aqua Queen, I think she's running behind. She's doing something. But yeah, I'm sure she may pop in. I don't know, but we'll see.
Pardon? Approach on this matter?
No.
On, okay. State your name.
Lawrence is a family of Buckner.
All right, go ahead, counsel. Mr. Johnson, go ahead.
Good morning.
Oh, hold on, everyone. Pocket watching with JT. Thank you for the gift, and I appreciate it. Yeah, thank you. Actually, I reached out to you on email, so check your email. I appreciate you putting one of my videos on your channel, so I did see that, and one of the members here watch you. Okay, so yeah, maybe you can reach back out. I really appreciate that. Thank you.
May it please this honorable court, Kareem Johnson, on behalf of Mr. Buckner.
All right, what are we doing on this case?
Yeah, I have received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that, Nelson?
John, I don't object to the outbreak exam or to defense counsel's request. However, lead counsel is new on the case, is not aware of something that comprised the public defender of. Earlier this week, this defendant made threats to witness at preliminary examination.
Yes.
A new charge,
Sir, you need to face me.
a new charge has been authorized against this defendant as a result of his conduct. And as a result of that new charge being authorized, we are requesting remand. We have previously advised the public defender's office.
It's in the office.
Your Honor,
Your Honor, this is,
Sir, I will give you an opportunity to address the court, but you're not going to interrupt You're not going to interrupt anybody. You're interrupted. Yes.
this exam was held on Tuesday, and after the victim in the case had testified, Mr. Buckner, during a break in the exam, threatened her in the gallery, and we did end up charging him with threatening to injure a witness. And this is a victim that he was not supposed to have contact with, as she was a victim on the FA case. So in that sense, he had violated the bond by contacting her in court and also threatening her with criminal charges, which is why we would be asking for his bond.
Sir, what did you want to tell me?
Sir.
Well, Mr. Buckner, I'd advise at this point you don't make any statements.
Mr. Johnson, I need to speak because if I don't speak, the prosecutor said they want to lock me up in remand. It's up to Judge Simpson. So I have to present my portion of the truth. If I don't, I'm going to jail. Like, I have a family to support. Please, like, I am not guilty. And this is what I,
Well,
okay, on Tuesday, I had a hearing for a situation that I was accused of, right? During that hearing, it is my belief, so let me just say that, it is my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was on, and I was talking to them, and nothing out of my mouth said, I'm gonna threaten that lady, I'm gonna get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times, 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify who shot you. You need to testify who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family. I got my brothers here. I got people that I support. I don't want nobody getting killed else. I died twice in my brother's arm. The next day, I got in an incident with my lady friend, and it went from a domestic violence to a stalking. Ypsilanti police officer Tyson came in to Washington County Jail. The very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it, and I didn't do anything wrong. The next day I woke up, I had stalking charge. That was dismissed. That was malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I go.
That is not my phone. Oh, and Colin, I saw you say McDuffie. Is she in the court? Because so I didn't see her.
I come to court, and the prosecutors, Judge Lorraine Washington is the eyewitness. This same prosecutor, while we was in court on camera yesterday, sir, while we was on court on camera, just please hear me, said Mr. Buckner is threatening my witnesses in court. This is what this same prosecutor said. Judge Lorraine Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening. See, they had already had it out.
Hold, stop. There was a video requested. Does the video show anything?
Okay, I thought that was her, but especially after you said it, I was like, oh yeah, she said that. That was a good one, Colin, because I missed it.
I haven't had a chance to review it. I just got it this morning. But we were informed immediately after the threat occurred. I and she informed our advocate and then informed us that it had happened. And then she did a police report, and then we authorized the charges.
Your Honor, may I?
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
Your Honor, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Your Honor.
Hold on. So Robert had to say this So I'm just going to put it up here for y'all to see. Nobody's complaining. I don't stop the video a lot. I'm going to acknowledge my members. I'm going to acknowledge super chats. And if people want to say things and we're trying to figure things out, that's exactly what we're going to do. But I'm sure there's other places where it may be unedited, but I am one of the least of people that do a lot of interruptions. Shall we go back to the video? And I'm sorry you had to cancel your membership, but it's okay.
Yeah. Mr. Brown, were you there on that?
I was not, Mr. Michael. First of all, one round deputy. I was not there, Mr. Michael Gaddy was. I'm not sure is this being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things there, and I don't know what there was a request made for video from this courtroom of that day. We got time narrowed down. You need to take your hands out of your pocket. And the request was made.
Okay, legal fiction, thank you, but I like your comment. He said I don't interrupt enough. Oh, Denali, I appreciate that. Y'all like the pauses. Yeah, I just try to make them quick because I know you want to enjoy the video. But at the same time, people that know me on this channel, I like to make y'all laugh. So I just do little things here and there. But y'all don't complain. It was only one person. He could have just moved on, but I don't know. Oh, another squid just became a member. Thank you and welcome. I'm going to have so many people to have fun with. And I appreciate all the love that's coming through here tonight. I really do. Oh, thank you, Silverlight. You always here too. Like everybody else, I'm just saying that because he brought it up. So now let's go back to the fun video. Uh-oh, wait a minute. Brian, I will keep doing what I'm doing. Thank you. I really appreciate that for the super. And yeah, I appreciate everybody here. There's a lot of love here. I'm not going to break down. All right, let's keep going.
Checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. That was, I think, Byrne provided to the people in this case. They have not had an opportunity to review it.
So as it stands now, these allegations that they have violated nothing's charged.
Well, no, it's basically charged. It's authorized at this point. It's just, it hasn't come.
Pocket watching with JT. Thank you again. See, I watch reaction videos to hear the host. Is the best part. Otherwise, it's just unedited vid. But we're supposed to make it fun. That's why we all here. We're here to have a good time. Laugh at what these sovereign citizens do. Laugh when Judge Simpson lays back in his chair like this. Huh? Okay, let's go.
Through the system yet. Okay, so here's what I'm going to suggest, and may not like it, but I think maybe this is the way to do it. The video, somebody from your office, Mr. Brown, was handling his exam, correct?
Yeah.
Okay.
We just talked about it.
He didn't see anything. So what I would do, and I get Mr. Johnson's point, he's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video provided to Mr. Buckner. Mr. Buckner. I
got pause again. Another squid. Thank you for the 5 gifted memberships to Sandy, Kalina, Bill, GK Tonic, Kathy, Wixom. I really appreciate the super chat you just gave me. Awesome channel. Discover you and Sovereign Citizen Crimes about the same time. I come mostly for the chat. I come to learn too. Keep it coming. All right, I will. Thank you very much.
I don't know what's on the video. I did not view it myself. And then have counsel look at the video, and then I will myself look at it when I get a break to be able to do so, and then make a determination if based upon that, his bond in this case should be revoked. I think that's probably the fairest way that I can potentially do. Yes, sir.
Sir,
appreciate you first and foremost for this opportunity. Can I say just to the court that upon looking at the video, the prosecutor said that I want the whole court to hear it. I physically said that I was going to threaten and get this woman.
Sir, first of all, I don't want you saying anything about what's going to be that new case coming up. I don't want you saying anything. I'm not going to hear it because you're going to end up hurting yourself. What I have said is you will be going into custody. We will then, and I'm not saying even at this point, I'm going to keep you in custody. A video was requested. I'm going to give, the prosecutor's got to look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with your attorney at that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out at least preliminarily.
Mr. Judge Simpson, I'm a very honorable person. I'm asking in all due respect. I'm not a flight risk, sir.
Sir, I'm not saying that you are.
My daughter's in the car. Is there any way that I can call my brother so he can come?
Sir, I'm going to expedite it as best I can to make sure that I can look at it, get you recalled back up, and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it, but it affects his case. But the people that can look at it can do that and maybe get in touch with Mr. Johnson. I don't know, but I'm just saying that's the way I'm going to handle it at this juncture. All right?
You don't represent me. Okay. So the guy that represents me is Mr. Gotti. Mr. Gotti is the key factor that you being here.
Okay, look, Mr. Buckner, they'll be able to talk to you back there, but I'll pass the matter. Sir, you need to just quiet down, please.
Okay, he passed the matter, and he also made him wait to the end of the docket, and that was a long one. Let's see. Oh, okay. I like when y'all messing with me in here. And the thing is, I didn't even say it in the Denzel Washington voice. I said it in my own voice tonight. All right, so here's the last part where he's going to do a lot of talking. This is where I really had to raise the audio. I was like, man, they got to get better mics at Judge Simpson's court. It depends on where they stand at that podium. Some days it comes through really good, and then some days it's a little rough, but bear with it. I did the best I can to fix it, okay? But I'm really enjoying this case because I've been wanting him to get into Judge Simpson's court, and I figured he was going to go to jail a different way, not the way that he just got remanded. I thought he was just going to make Judge Simpson mad and say, you know what, Mr. Allen? But either way, he still went in the back because he did the violation. Okay? All right, let's go to the next part.
Court does call the case of the people versus Lawrence Buckner.
Joseph McMillan, people, Your Honor.
Oh, real quick, I don't know. Something's going on with him because in Judge Washington's hearing, he was in a car. And then after that, I've been seeing him in wheelchairs. So when he walked in, because actually his hearing was today, when he walked in, I was like, oh, he's okay now. Now he's back in a wheelchair. So he must have some intermittent problem going on with himself.
All right. Mr. Johnson, you're muted. Go ahead.
May it please the court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right. Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right, your name, sir?
Sir, my name is Lawrence Edward Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir?
He did the same thing when he had his when he was in Magistrate Garwood's court. She kept asking him questions. He put his head down when he was in the wheelchair like that. And then he just wouldn't answer for like 15 or 20 seconds. I don't know what tactic he's using, but I really don't understand that.
And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. You understand that? Mr. Buckner, you can sit down while we go through this.
All right, so I didn't know. I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, forgive me for my emotional outbreak. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are. You may want to mute that.
I'm sorry. This is my freedom just snatched me, and I was understanding this Sunday where I came to that charge me. See, I told you I got shot in the head, so you got me hearing the wrong thing. Okay, and you said it wrong. Video, but now you tell me no video. That's what I'm not understanding, because the whole basis of my freedom today was Judge Simpson in the video, and that's why I need help. Oh, what charge is this? This is the charge of having April 4th in Judge Washington court? Okay. Potential. I understand the potential. I just, from the time, I apologize ever since it. I'm a little slow right now, so I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge that Ms. Johnson, Ms. Washington, one of Yeah. I understand, Judge. I'm sorry, I don't.
Okay, so you understand then the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case.
Right.
As to the formal reading, you waive any further formal reading of the complaint, stand in. All right. All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea.
Yeah, I gotta stop real quick. So I just was made aware of an incident going on in the chat. That's not gonna happen. They cannot comment anymore. We're here to have a good time. Anybody want to do something other than that, you want to get kicked. Period. Okay? Because I got wind of it from Colin and I started seeing other stuff. This is a fun environment. So nobody's gonna talk mess, which nobody really does, but I'm just putting it out there. We're not having that. This is a fun night for everybody. Just I didn't have my moderator in here tonight. So luckily Colin was able to let me know what was going on. So y'all continue to have fun. But if y'all see anything, make sure you just send it in the chat. If I miss it, and I'm gonna deal with it.
Set a probable cause hearing. And Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
Stay in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I don't want you to tell the judge to adjourn something. And then I need to be heard on it. And I could find out I did nothing wrong. I need help. And helping me is not leaving me inside watching our county jail or trying to put me on some type of crazy bond. Like, I need help.
Okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that for 20 seconds, not.
All right. As to bond in this case.
The allegation here is that my client allegedly had some outbursts and witness. I had a chance to look at what was available on the court. There was nothing. I'm looking at weakness and strongness of the argument. Charge with destruction is weakness and intimidation. That means that he was trying to prevent this witness from coming to court, testifying, trying to change what this witness had said. All of that goes to whether that witness would be able to appear in future court. Taking the best of what we've heard from the prosecution. Said you've been lying on me. The said that's my client. It's not saying he said that. But what the prosecution says that I should kill you or something to that effect. She should you or kill yourself. Yeah. Motion is for threatening intimidation. Is that he has to be doing something to prevent this witness from saying, don't come to court, trying to stop this witness. I think even if we hold her to this allegation based on her, I don't think the prosecution should be able to make out a case that his intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, testify truthfully. That's what this is saying. Because I do not believe that he will be successful in conviction, I'm asking the court set for my client a personal cognizance bond. And here's the reasons why a personal cognizance bond. You have the ability to have no contact. It has a home in Ypsilanti, 680 box. It's not having anything to do with money witness lives is separate. He's self-employed, he raises dogs to sustain himself. He suffers from numerous bad injuries. I believe that was already been raised that he's been shot 9 times. So he's got health problems that arise from that. Finally, he lives with his autistic needs, he has to take care of. He also has a brother who can help make sure that he returns to all future workmates. It's a responsible individual. They should.
It's almost over with the
charge here is a strong charge. I think it's a charge that even taken in the light most favorable to the prosecution, they will be able to prove that he probably caused that.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam is on first Tuesday. At that time, the victim testified and examined. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked her to go to the bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and his assistant prosecuting attorney. Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she had testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, Your Honor, people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court exam. The condition of the bond in that case, case number 5-121, I'm sorry, I may have misread that case number, was that she had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that they have no contact with the victim in Hudson, have a no-go to order as for a residential place of employment. And frankly, Your Honor, is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during the court proceeding, immediately after the testimony of the victim, is gravely concerning to people. And to our mind, points to a need to set a significant bond to secure the safety of the public and the state.
So I'm going to respond, Your Honor.
Yes, sir.
Obviously, very clearly needs something different in the prosecution that they describe you as an angry outburst. It doesn't rise to showing any intent to keep anyone doing anything except that angry outburst. They went big head and tried to charge a witness intimidation. It's not that the person already testified.
It's messed up right now. Okay, let me say something else. Quietly, what was it? Quietly Soulful? I don't want to mess the name up. I guess he felt ignored in the chat because maybe nobody said anything. I don't know. But right now, I have like hundreds of chats moving like crazy. So if I miss some people, most of you should know how it is. It's kind of hard to do it because my moderator is not here. So everybody is welcome. If I miss your chat or something, because it was a few that came up and they move so fast, and I'm just trying to make sure I keep y'all entertained, that I wasn't able to get into the chat and respond really quick because I normally do, okay? So let's have fun. It's been kind of a strange night, but still a good night, okay?
Said she was lying. It was angry. It was an angry outburst. But we're not going to try this. Here to show the prosecution is that the court takes into consideration the likelihood of conviction. The likelihood of conviction is, as the prosecution says very clearly, I think that's the case at all. And what you have is not angry outburst that's being spun, something based on what they saw in context, an unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you'd agree.
That's right. It's making a line with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging this case, And with the discretion to give it decide. Context of whether or not they would likely to get a conviction based on that flimsy information they have there. That's not right. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging entire case. They can't complain to them and say, oh, well, you know, we got a new case based on that.
So there seems to be a misperception because the victim had testified at an exam that somehow this conduct was not committed to the victim. The victim's testimony would be needed at trial. And to make this statement, not only that he accused her of lying, but that he was going to get her. When the same victim has seen this defendant firearm at her and racked her weapons, clearly the intent here was to intimidate the witness in question. So based upon this defendant's conduct, I need a $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to pose yes or GPS tether, it will go conditions as to placing employment residence to the victim. But very clearly, this defendant demonstrated.
I don't know that I have a name for the.
The name of the victim, Your Honor, is Amy Hudson. That's A-M-E-E. The first name. Hudson,
Say again.
A-M-E-E.
Okay.
Last name Hudson, H-U-D-S-O-N.
All right. Anything else, Mr.
No, the way it works is it's on a motion, they respond, they make a response, and it's supposed to stop on lunch.
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm going to order standard conditions, really no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy Hudson. You're not to go to either direct or indirect or through third parties. I will also indicate that there should be no mention of Amy Hudson on any social media or any use of any type of social media. You're also not to go to that person's residence or employment, or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate, should it be. That type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
This Washington from Judge Washington. It's probably the same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington could have helped me on this. Because they got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom. So.
Okay, and sir, this is the time that I got arrested and you sent me back here, the things that I was trying to work on you was, I mean, the community of people that was helping me, sir, and I know everything I'm saying because you already made a decision, is that the video inside Judge Washington's courtroom, a Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, "No, he's not. He ain't looked at her. He ain't said to her. He's mumbling things to me, trying to get my attention." This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown, Mr. Brown. Yes.
Thank you. No, I don't, but the conditions still.
Woo. That was a good hearing. And he has more. So he's going to different courts within the county for different stuff. This guy. So I'm definitely going to be bringing him back because he is just interesting. Every court hearing, he's doing something kind of different. Well, he was definitely different with Judge Simpson versus how he was in the last two courts. He didn't bring his Bible. But I thought in the beginning when he first walked in, it looked like he started praying. That's what he did in the last two courts. So I think he has to see Judge Simpson again, and he has to go back to Judge Washington again. So I had to keep an eye on him because I was trying to follow his court hearings, and he kept popping. They had him assigned to Judge Simpson at one of his hearings. He ended up in Magistrate Braley's court, but I already showed that video. So what's going to probably end up happening is with all these hearings, I might just put it together and make it some kind of movie or something. I don't know, but thank you everyone that watched tonight. Thanks for all the super thanks. Thanks for the members. Thanks for the subscribers. And thank you all just for keeping up and watching my channel. I'm glad y'all been enjoying it. Let's see. Yeah, I'll talk to Colin. I'll be doing another live stream with him. We're going to be coordinating some stuff. And also for people that are here regularly, I'm probably going to do like an earlier live stream so that I can raid Colin back. Okay. So for those of you who are here regularly or the people that don't know, I normally do my streams very late, 11, 12 o'clock at night, because there's a certain group that's on. So I'm trying to back it up a little bit because I want to be able to raid Colin so we can all bust in there and get him since he does his at 8 o'clock Eastern Standard Time. Okay. So I really appreciate everyone watching and hanging out with me tonight. It's been fun. We had a little hiccups in the chat, but like somebody mentioned not long ago, it's part of the growing pains, right? My channel's growing, so I'm going to have different stuff going on. It just happens. But if I see anything or anybody get offended here, it's not going to be about me. But something happens in that chat and y'all let me know, or it's going to be handled immediately because this is a place of fun, not a place of drama. Okay? All right? I'll see y'all around on the next time. Thank you once again. I'm out.